Okay, hello everyone. This is Curt and welcome to another edition of Fire Law Roundup for October 10th of 2022. Brad, welcome back
Yay,
from
I'm
2
back.
weeks off and your trip to Europe. I'm sure that was
Fantastic.
yeah, awesome. I'm jealous. So, let's get into the week from the cases from last week. A couple of pretty important and interesting cases.
It's like disability week. I think this is, the 2 weeks ago when I last left, it was like discrimination week, which it always is 65% of the time, right? But this is kind of disability week. But let's not start on disability. Let's start with a stripper, because whenever you have a stripper and the fire service, we should start our talk about strippers. And I'm going to have a very different view, I think, of this. So look, there's footage. You should watch it. Some of it's commentated footage, but it's on, Curt's blog. So you should watch this. It's you can't describe it, but a fire truck pulls up to a strip club and this scantily clad woman gets out and gets out of the engine, out of the back of the cab, and walks into the strip club. But I want to change the facts before we go into the public uproar.
Okay.
Because as you can imagine, as everyone knows, there's now a video, and that's the public uproar. And there are two comments made. So first, let's talk about the comment, then I want to give you my thought. But so the first comment, the chief right on, right? He said, if the findings of an internal investigation reveal inappropriate behavior, appropriate steps will be taken. Good comment. We're investigating. We're not prejudging the issue, which will come up later in another one. We're not prejudging the issue, and we're just saying we're going to look at it. Then the mayor comes out and screws it up, I think, and says, if the investigation concludes that the video is as bad as it looks, then heads must roll. Okay, let me change the scenario. It's not a stripper, and she's not scantily clad. Now it's an 80-year-old woman who was found walking the streets in a bad area, and the fire department, returning from a call, picks the woman up, puts her in the firehouse, and drops her off at the house. Would anyone say anything other than, what a nice person, what a nice group of firefighters, you did your job? We don't know a lot. I'm bringing this up for a reason. We don't know a lot. We don't know where she was picked up. We don't know if she's walking in a bad area, right? We don't know if she was, assaulted before. We don't know anything other than you have one snapshot of something, and you automatically, one, judge the person, the stripper or whatever. I mean, she clearly looks like she's somebody in very few clothes who are going to have fewer clothes later on, but they immediately prejudge the issue. They, not the chief, by the way, not the chief, the mayor. Good job, chief, right? But they immediately prejudge the issue. They evaluate the person. They take their own prejudgments about the person and then immediately assume there's no reason why this individual could be why the fire department would ever help this individual. Because again, I say, if an 80-year-old woman got out of the fire engine, you wouldn't say anything like this. Mm-hmm. So I use this as it's like, Curt knows what I'm talking about. It's like, there's that video you tell everyone to watch, and then a bear walks across it or something. And everyone's like, did you see the bear? You're like, what bear? Like, okay, watch it again. And then everyone sees the, whatever it is, monkey bear, whatever it is, walking across. Like, I didn't see that the first time. Yeah, because we're fixated on something else. That's the point. We take something, it creates something in our mind, and we immediately prejudge it. And in any investigation, that's not right. So my only point about this little tiny thing you posted is, go with what the chief did. We're investigating. We'll make a determination that's consistent with our investigation conclusions. Yeah.
And let's, that's a good perspective. I just want to go through the facts again, that we have a woman, the newspaper describes it as a bikini. From what I saw, it's not the kind of thing that people go swimming in.
No,
but it was a bikini shaped suit,
glittery
uniform.
Okay,
uniform.
It's a
work uniform.
For somebody who dances on a stage.
She exited a San Jose, looks like an engine company. Looks like she got out of the back, the jump seat area, and walked into a strip club.
Right.
So
Presumably her place of work.
that's right, presumably, but who knows? Okay.
Right.
And who knows if it's a she, let's not prejudge. So,
Right.
But at any rate, it appears to be a female, appears to have gotten out of the back of an engine and walked into a strip club. Somebody's got it on video, shows up on, I believe it was Instagram. Okay.
Yep.
Now here's my take on it, because I've had to investigate similar types of things. Typically when these things happen, it's not the first time that something like this has happened in that organization. Now, maybe it is, maybe it just so happened that it was the first time, but often it's not. And I often go back and try to figure out where were the opportunities that were missed in trying to get this behavior to stop. And very often,
if it's an appropriate behavior,
assuming, yes, but it certainly has bad optics.
Yes,
okay?
horrible.
And let's say she wasn't walking into the strip club. Let's say maybe she was walking into someplace else, but the fact that the engine is parked outside the strip club certainly adds another dimension to the whole story. But again, the point being, were there opportunities in the past that the department could have found out about this, but for a number of reasons, the department chose not to do something about it? They didn't start an investigation. Maybe it was an anonymous complaint. I think that's one of the biggest problems that we have, is sometimes we get an anonymous complaint. And we say, well, it's anonymous. If it's not important enough to you to report who you are, then we're not going to bother investigating. But there are opportunities not to fire people. I'm not talking about firing somebody or demoting them or whatever. What we're talking about is getting the behavior to stop. And sometimes just by investigating, by taking complaints seriously, even complaints that we're not going to be able to discipline people for, but by taking them seriously, we can get the behavior to stop. And then we don't have this kind of, take your breath away kind of headline. Which is good for us, and it certainly is good for my blog and for the news media to have stories like this. But it's not good for the organization. It tarnishes everyone in the organization, and it's not necessary.
Right. But again, we don't know the facts.
We don't know the facts.
And
well, we do know that.
I really hope they say, we picked this woman up walking on a really bad street. We felt she was in danger. We asked her if we could take her somewhere, and that's where we took her. Yeah. That's what I hope this is. And again, I say, I think we're judging people, and we're judging the firefighters, and because you're immediately saying, what possible good could they be doing by having somebody dressed like this and dropping her off? But I really thought maybe they picked her up in a bad area. Funny story, not funny. But my first night as an acting lieutenant in Providence, I think I had been on the job maybe a year and a half. Just long enough to be allowed to act. And I ended up, the two senior firefighters over me were on vacation and the captain was on vacation. So I ended up being an acting lieutenant. Okay. My first night as an acting lieutenant. I had been a lieutenant in another department prior to this, but it's my first night. Okay. We get a street box. So show up at the street box, and there's a woman standing in some bushes. It's like 2:00 in the morning. She's naked. And she's standing in some bushes waving. She had been raped. Somebody broke in. There's a crazy story. She'd been raped. Somebody broke into her apartment, raped her. She was able to get away. Somebody else picked her up, drove her to this desolated place, and he raped her. She had been raped twice, and it was not a very good neighborhood, by the way. Okay. Go figure.
Well, that's, a lot of fires and a lot of problems. Okay. But so, we ended up with a naked woman in the front of our truck. Now we put a blanket on her and did all that. Okay. But point being that there are things that happen. Now she didn't seem like she had been the victim of anything, but who knows? Who knows? So to your point, let the investigation, be carried out, and then we figure out where we're at once the investigation's done. And
don't make comments like the mayor made. Make comments like the chief made. I thought the chief had it. Anytime we can say a chief said something good, I think we should. And this guy was right. We're investigating. We're not making any other comments.
Yeah, sometimes when people run for office, they're more worried about how can I spin this to my advantage and show that I'm a good politician, and that sounds like what the mayor did.
Well, and you're going to look like a real ass when, if you find out that my made up story is right, and you just what you did is you prejudged your firefighters. You said we're going to hang them out to dry, basically, and now, right? So why isn't, like, the chief? The first thing is we're going to investigate. I'm not going to say anything to anybody about anybody. We don't know. So
I agree.
Okay. All the more serious stuff, and then I will get into it's so let's go to I just have notes. Let's go to Georgia, if we could. And here we have a Georgia firefighter. He was terminated. Every one of these that we're going to do now are a little bit confusing. They're mostly the rest of these are going to be filed lawsuits, not decisions. But here we're starting with a decision. But here he was, and this is so it. We could spend 2 hours on each one of these. They're so good cases or allegations to talk about. So I'm pulling a little bit out of each one that have some common theme. But here, a Georgia firefighter was terminated in 2017. He was involved in an off-duty accident. And he lost his suit. He tried to regain his job. He sued. He was, I guess this is allegedly, but while off duty, he was charged. He was arrested and charged with DWI. Important to note, very important to note, those charges were dismissed. Now, I don't know if it was, a settlement. I don't know if he did some course. All we know is it was dismissed. I don't know if that means he was actually found not guilty. Who knows? Or maybe it was a bad traffic stop, right? I get people off for bad stops all the time. Maybe it was one of that. So in any event, he was also a little obnoxious to the fire department who arrived, his own fire department, when they came to help him. In any event, the facts are a little bit disputed, and the plaintiff, the firefighter terminated, had suffered a head injury, so he was kind of blurry as well. So that doesn't help when he doesn't even know what happened. But nonetheless, this is about the investigation and termination process, and he loses. So I pulled out of your blog, pulled out some of the salient facts. So let me say these. So in July of 17, he received notice that his employment was terminated, effective 2 days prior. The official reason was offensive conduct or conduct unbecoming an employee of the county on or off duty. And the big one, I think, failure to cooperate in drug and alcohol testing, which to me is an on-duty issue, not an off-duty issue, right? It would have been, well, we know something happened to you off duty, so now it affects your on duty. That's fine, I think. So anyway, he was given instructions on how to appeal the termination. He does file the appeal a couple days later. He has a hearing a couple months later in September of 17. He brought an attorney, and this is what's a little weird. They get a hearing officer, and the hearing officer found that the evidence supported his termination. And he then, only months later after that, in February of 18, he's now acquitted of all criminal charges. Now, they already made the decision, you're terminated, and the hearing officer says you have the right to be terminated. But it was pending charges, which is why I don't love that portion of this. Look, if he was uncooperative with drug testing and everything, that's a different issue. We'll get to that. But nonetheless, he's ultimately acquitted of drug charges. This is funny because everyone who's listening, keep holding off on the next one or the one after that, when we're going to see, oh, it turns out you don't have a disability, or maybe you do, or whatever. So things that happen later. So the first question is, well, if you don't know something now, like what's the result of your charges, do you take action based on just an arrest, innocent till proven guilty? Okay, so he files suit against the county and against the county manager. He claims that his procedural due process rights were violated, and you do a whole course on this, Garrity, all right? And he says, my Garrity rights are violated. I'll let you give a little summary on that. He says there was a breach of contract and they were negligent. In any event, he files it. He claimed that he had a property interest in his employment, which he does. The reason that's important, saying property interest, so that brings in the constitutional rights, and you can't be deprived of property interest without being given due process. But the holding is pretty simple here, because the judge agrees, listen, you do have a property interest in your job and you are entitled to due process in some sort, but you didn't point out here what due process you weren't given, although he tries to say an impartial hearing officer, but he really doesn't point out. He says, look, I have all these rights, but the judge says, yeah, but you didn't point out to any specific right that wasn't violated. So he ultimately loses. And I think that's it. There's nothing, unless you'd have a different opinion, because I want to focus on what I was going to. But in the end, they say, listen, you had a hearing, you're terminated, and you were given all your rights. So
Yeah,
I think there's nothing groundbreaking.
Yeah, I think I do have a different take, because one of the things was, if you go back to the facts here, let me just scroll up to them. He was terminated on July 5th. He was actually given a Loudermill hearing on July 5th, but his termination was retroactive to July 3rd. Now, how does that work? In other words, you were already terminated.
Right.
We're giving you a Loudermill, but you were terminated on July 3rd. So I think that's a due process violation. How are you giving me? You've already made the decision to terminate me. What good is a Loudermill hearing at that point?
Well, and that's the question. Did they make the determination, or did they just determine it later and make it retroactive?
Made it retroactive. And that's a fair point. It wasn't fully, but to me, these are questions of fact. They're not questions of law. And the judge should have, I disagree with the way the court handled this. And I think this is, it's representative of a problem I have personally, a philosophical problem with federal court these days, where they're playing judicial keep away with people's rights.
Right.
Okay. And I mentioned that. I go on, a little bit of a soapbox at the end of the post here about that, but I just see the federal courts, and I know why they're doing it, because otherwise they don't want to see an endless stream of really strained due process type cases in 1983 type situations. So again, attorneys will know the code words that I just used in that little explanation. But point being, I understand what the courts are doing, but this is an example where there are legitimate due process questions. There's a question about whether or not the county manager was actually neutral, or if she had already indicated that she made up her mind. Those are factual questions that require a fact finder, not a judge as a matter of law, a fact finder. And what the court basically said is that, well, the county has qualified immunity, and you haven't alleged a policy and a practice. Therefore, even if your due process rights were violated, you don't get your day in court. And you didn't show that, and I want to get the phraseology correct. You failed to show that it was, what's that term? Clearly established.
Oh, yeah, it's funny. Okay? I bolded that.
So yeah, so you did not show that the due process rights that such as a neutral person and the right to a Loudermill hearing, that those are not clearly established. And the Loudermill is a little different, because the Loudermill goes to the county. That was, county's liability, whereas the clearly established goes to whether or not the town man or the county manager was actually neutral. Okay, but here's the thing:
how could the county manager be neutral? He's not neutral.
Well, and that's but point being, the factual allegation has been made. You have a right to have that heard on the merits. You shouldn't short circuit that, because then what it does is it sends a message to other people in that situation that, well, the courts are going to dismiss it on qualified immunity or not clearly established. Therefore, we can violate people's rights. That defeats the purpose of even having a due process clause in the Constitution.
Right.
And the courts don't seem to grasp that. They're up in the their heads are in the clouds, and they're not grasping the impact of those kinds of decisions.
And to jump on that, what I was shocked at were two comments in here. One that they said oral or written notice of your rights would be acceptable. Oral is not acceptable.
Not usually, not usually, but I think, there's a difference in that Matthews v. Eldridge case. I don't know if you're familiar with Matthews v. Eldridge, but I call it the Matthews v. Eldridge blah, blah, blah balancing test. But it's the balancing test for how much process do you have to give someone.
Right.
And if you're going to give them a reprimand, it's one set of requirements, okay? But if you're going to terminate someone, so termination being the most serious deprivation that we have, it's different. And generally for termination, you've got to have written notice, okay?
Right.
For a reprimand, no. A reprimand can be oral, okay? So generally, as a general rule, oral or written, yes. But for termination, generally, it's like being indicted. I mean, when you're going to indict somebody on a capital offense, there's a certain process. When you're going to, arrest somebody for disorderly conduct, there's a different process. And that it all goes back to Matthews v. Eldridge and that balancing test. But
and I forget if it was this one, but I thought, because we have a couple of them that are kind of similar, but I thought
right.
It was this one where he said, you didn't even cite a policy that I violated. And
Right.
that was my big thing. Wait a minute. In New York, at least in most states, you better be able to cite, here's what you did wrong. We told you
Mm-hmm.
couldn't do it, right? This conduct unbecoming sometimes has been held to be so vague that it's
Right.
not a reason to dismiss somebody. But when you have off-duty conduct,
Mhm.
or you're required to submit to a drug test, I'm assuming they're a collective bargaining here. I don't know, but they refer to a contract.
Georgia, maybe not. I think the breach of contract is the basic employment contract.
Oh, okay. So
Okay.
so I didn't see that. And of course, there's no union here defending them,
Yeah,
but that
no,
doesn't mean
it's
anything.
not a union.
But drug testing is a mandatory topic of negotiation, right? It's
If
mandatory
this is off
bargaining.
duty, this is off duty though.
And this is off duties, which
It's off
one
duty,
step
so-
removed.
Yeah.
So there better be a policy.
Again, but see, and going back to my point, he never had his opportunity to raise that in a
Right.
hearing,
Right.
and or at least at the Loudermill hearing, okay, because it was a decision that had already been made. So, at any rate, and
that's well, but let's keep going that for one more thing, because the other thing that should have happened on this, and this is going to link to a next another case we're going to talk about, is he was just arrested. There was he wasn't found guilty. And yes, I suppose you can always try to prove your own criminal facts in a sense, right? And they could have brought in the other people and say, was he drunk? Did he smell like alcohol?
Yep.
All of these things. But then you still get, wait a minute. How do you know he was intoxicated? How do you know it was alcohol?
Injury. He had a head injury.
Yeah,
maybe that's why
acting
he was,
confused.
acting the way he acted.
So that's really why I question, why are they acting before they have a guilty or not? And I'm not saying guilty or not guilty means anything. Guilty sure does. You're found guilty by a jury, right? But he then turns out to be acquitted, or maybe not, maybe just charges are dismissed. I'm not really sure which it is. It matters. But, acting before that, I would have put him on unpaid administrative leave. His attorney probably would have been thrilled. Let's see what happens, and then we'll take action after that.
Yeah.
But okay, I wouldn't have done it this way, and I don't. Obviously, you wouldn't have either.
No, I wouldn't. And we could get into Garrity, but it just belabor this particular case, and there's really not a Garrity issue in the case. So.
Yeah, I didn't really see it, although they said it. But okay, let's go just a little bit more.
Unless they discipline him for remaining silent. And again, all we have, and folks that read the blog, you can read the case, you can download the case. They didn't get into this. A Garrity issue could come up where they order him to answer questions about what happened, and he refuses, and then they discipline him for refusing. Because Garrity doesn't apply here. It's not work related. Garrity only is triggered when you're ordered to answer work related questions.
Unless off-duty conduct, I've never seen a case on this, so this is my own thought.
I've got all of them. So
if there was off-duty conduct that said you cannot drink and drive off-duty, right?
No.
Couldn't that then relate to on-duty?
Yeah. Now here's the way to approach Garrity. Okay.
See, we're not going to talk about Garrity.
No,
Let's talk about Garrity.
but this is the way to think about Garrity. Okay.
Right.
If the chief can order you to answer questions, the chief has the ability to immunize your conduct from criminal offenses. Okay. So you think about that. If a chief can order, let's say you have a firefighter driving an engine impaired.
Yep.
Okay. And so now they get in an accident, the chief does an investigation, orders the firefighter to answer questions, and the firefighter says, yes, I had a pint of vodka. Okay.
While driving a crime.
That information cannot be used by the police. In fact, if the police get access to that information, they won't be able to convict them.
But if you don't give them the warning up front.
No, all you got to do is compel them for that to trigger. Okay. So now, same situation, except he's off duty. And the chief calls him in and orders him to answer questions. That would give the chief the ability to immunize off-duty conduct. And the courts have said, no, you can't. Therefore, the firefighter has a right to remain silent for off-duty conduct. Now, that doesn't mean you can't punish him. You can punish him, but you just can't use the firefighter's silence or his refusal to answer questions against them. You're going to have to prove it in a different way. That's sort of Garrity in a nutshell.
Okay. And again, we don't really know exactly what was it. Was it the off-duty incident? Was it you refused the drug testing? At least what I saw was a little vague to me, but yeah. Okay. So let's go a little north from Georgia, or a little south, I'm sorry, from Georgia. We'll go to Florida. Here we have a Florida fire lieutenant. He's demoted for insubordination. He's then terminated because he refused to accept the demotion. They raised a lot of FMLA stuff. My comment is this is not even close to FMLA, but I understand why they thought so. So I guess kudos for the attorney, but we'll talk about this. So he's lost. He tried to, in federal court, he lost, he sued. He tried to get his job back. He claimed that his employer violated the Family Medical Leave Act, which I'll summarize for our viewers quickly, when they demoted him, and that he violated FMLA and the Florida Disability Discrimination lawsuit when they terminate him. So just very quickly in FMLA, all FMLA does is it gives you 12 weeks or 26 if you're military, but 12 weeks per 12-month period of unpaid leave guaranteed for certain medical conditions or certain events, not everything, just certain. And once that time runs out, that's all you get, 12 weeks. It's not like an ADA usually plays in, right? But it's not like ADA, which is kind of a continuing, you have to reasonably accommodate. This is, you get 12 weeks and that's it. So I'll explain why they go to FMLA, but anyway, and interestingly, for those who haven't attended we've been doing about every 3 or 4 months, our FMLA lectures, we talk about this exact issue of job reassignment. And I love the issue. Okay, so he said he disclosed that he has a psychological condition, which was, I think, PTSD here. He discloses that, and then he says he's treated less favorably. So it's interesting. I don't know why ADA isn't here. I get Florida disability. Maybe he missed the time, 300 days, you have. I don't know. But I'm sure as you were shocked, why aren't we talking ADA? But nonetheless, I guess
I assume Florida law gave him some strategic advantage that the ADA wouldn't have given him. That was my assumption.
Yeah, that could be. So here's basically what happens. So in 2018, in March of 18, he injures his hip while off duty. He's on protected FMLA leave, which it would be, and he's released to return to work without restriction. He states that while he was on leave, he was harassed by a fellow firefighter. Now, that could violate FMLA, being harassed because you're taking a leave. That could be an FMLA violation. Anyway, so he was then promoted to lieutenant. Now, I got to tell you, I don't know who's advising this guy or whether he was just I'm going to bite my lip. I shouldn't say what I'm going to say, but you'll all draw your own conclusions in a moment. So he's promoted to lieutenant in July of 18. He nonetheless, he contends he was placed in a much less desirable position when he returned to work because he's transferred to a different station. Now,
even though he's promoted, even though you're promoted,
we're going to transfer you to a worse assignment. Come on, right? Okay, that does. And so my notes I wrote does not rise to FMLA. You were not treated less favorably. You were treated favorably. But the guy being his own worst enemy, and I apologize to you, not you, to Mr. Chandler, I'm not trying to be mean, but while he's on probation in his new position, he failed to report to work. Generally, that's going to get you fired at a lot of places. In any event, so he fails to report to work. He speaks with his coworker, tells him the stress of work trauma and consistent overtime. I think this is mandatory overtime, but consistent overtime was impacting his home life. And so let's phrase on that, impacting his home life. That is not a medical condition. All right. There's nothing protected about impacting your home life. Okay. And he requested an employee assistance program, which he was then provided, right, in the EAP. A month later, he has a verbal disagreement with his district chief, right? And I like how the lawyer phrased it as a verbal disagreement. I'm sure that's not what it was. We'll talk about that. Over a mandatory overtime assignment. So mandatory overtime. And he denies that he got into a fight with him, but he admits saying that it's bullshit. I'm sorry, when you tell chief that a mandatory assignment is bullshit, you're not doing yourself any favors. So he then accuses the chief of being retaliatory for what? Assigning him mandatory overtime, and he refused it? Okay. So the department initially says that they considered terminating him for insubordination. That would have been, I think, their strongest, right? For the verbal altercation. You tell a chief that it's bullshit and you don't show up and blah, blah, blah. But instead what they do is they demote him. I mean, that was pretty good. He was probationary. They had the right to do that. And it was only about his attitude. Had nothing to do with any disability. At any event, they place him on probation for a year and he's demoted. He then is terminated because he refuses to accept his demotion and his new assignment. Okay, insubordination again. So he then sues. The case gets moved to district court because of FMLA, which is where I think they messed up. Right, that the defense lawyers saw, we can get it to federal court and they're not going to stand for this. So there must have been a reason they wanted to be in state court, because so everyone knows, most attorneys like to sue in federal court because most of the discrimination and retaliation laws pay the attorney's fees regardless of what you recover. Many states don't give the attorney that, so you can never find an attorney because you ain't getting paid. Okay, so the judge rules that the department never interfered with his FMLA rights, and they were dead right. There was no FMLA issue here, nor did they retaliate against him for FMLA leave, right? This had nothing to do with FMLA. And they held on the state law claims that he failed to establish any viable discriminatory disability discrimination. And that's true because, right, we talk about this all the time, the shifting burdens, right? I don't even think he made out a prima facie case. I don't think anything he said had nothing to do with his disability. I mean, saying you impacted my home life and this is so much stress. That's not PT. And I was wrong when I said PTSD. That's actually going to be another one, but that's not PTSD. That's just stress. That's not a disability, right? You can't handle the stress of your job does not make you disabled. In any event, this got kicked. Don't tell your chief that you think his mandatory overassignment to you is bullshit. You're probably going to lose in court. They could easily prove they had a separate, unrelated reason to any alleged or perceived, which there were none, disabilities. This guy just seems like he was a problem child, and I'm sure this wasn't his first time. But man, the department really went right. They could have gotten rid of him right. You're not going to accept your assignment. You're done. But they did good to him. They gave him a chance. Mm-hmm. Well, I don't know anything more we need to say on that. That was a good. No, just it sounds like a couple of cases I've had to defend firefighters over the last couple of years, in a very similar factual pattern. And, I mean, it's a tough situation. You got folks that are under a lot of stress and they're not making good decisions. And, they engage in this kind of behavior. But what I don't forgive is the attorney. The attorney should be looking and saying, you have nothing, and when you're looking at FMLA, I won't get off. We could talk about FMLA for hours now, but there's no FMLA. You're promoted. That's retaliation. Well, I think unless they can find someone who is similarly situated that did not take FMLA and got different treatment, and then they're going to say, oh, well, you did this to me because of because I took FMLA for my hip, this is all sort of a follow through on that. But that's
that's a tough
stretch.
case. That's a tough case. Yeah.
Okay, so let's go to a better one. This is really interesting. I mean, super interesting. Let's go to LA County. This is a really interesting case. It's just a lawsuit at this moment. And you could teach a course on this case as a part of it. So we have a Los Angeles County firefighter. He was prohibited from returning to active duty. He was ordered to retire after he had 2 seizures while on duty. All right. And look, everyone should know the fire brigade standard 1910-156, I think, says that, if you have the seizure, you shouldn't be an interior firefighter. So he has 2 seizures and he's suing now over disability discrimination. I love these facts because they're so interesting. So he's a 16-year veteran of the fire service. He has 1 seizure in September of 18, and then shortly thereafter in January 19, but then he's been seizure free since that time. In September of 21, he is perceived to have a 3rd seizure, which turns out, and I don't know if that was, people just saying it or not, we don't know. But he was perceived to have it. And by the way, the perception of a disability is the same thing as having a disability for the purpose of ADA. So he's perceived to have his 3rd seizure. It turns out he didn't. But this is where it gets really interesting. So he now sues over employment discrimination, failure to accommodate, and failure to engage in an interactive process under California government code, which I don't know anything about. But let's talk about failure to accommodate. Now, first of all, I don't know how you accommodate an interior firefighter having seizures. You got to get
I think it's just length of time that you're not going to require them to, the length of time that they're going to be assigned to a light duty position. I think that's really about, or there was some accommodation he was asking about a modified shift schedule that would allow him
we're going to talk about that. Yeah.
Manage his sleep. Yeah.
That's one of the great issues in here is asking about something that doesn't exist. Right. So, okay. So, but they did temporarily accommodate him in a light duty firefighter position. And so we'll keep going through it because my first question is over a temporary light duty accommodation. Does that mean, well, if you could do it temporarily, you could do it forever? Right. So is that a reasonable accommodation? I would say no. It's not reasonable to take something that's meant to be temporary and turn it into something permanent. Just because you did it on one day, now you have to do it forever. But great issue number one. And I think he loses on that. In any event, so here's what happens. He goes to his personal physician, right? And very important. And by the way, if we're talking FMLA, you'd have to abide by the personal physician's decision, but for ADA, I don't think you do. Different laws, different things. Okay, so he goes to his personal physician. His personal physician says, listen, no stressful work, and right, kind of tough, and you can only do a 12-hour shift, but they do 24-hour shifts. So his physician says you can only do 12. And now he says, well, you have to reasonably accommodate it. How do you reasonably, remember to all our viewers, the ADA does not say you have to accommodate. The ADA says the employer has to reasonably accommodate. And then the legal, not factual, legal question is whether an accommodation is reasonable or not. And I, right off the bat, am saying, I think he loses on that part. Because telling someone you get to work half a shift when your union negotiated 24-hour shifts, how is that going to be reasonable? Right. In any event, that'll be an issue. But so then he goes to the department's physician, same conclusion that he's not fit for duty. And then it turns out that 3 days, I think if I'm getting this right, 3 days before he went to the department's physician, he goes back to his personal physician who said, well, I removed the restrictions. You have no restrictions. To which I'm saying, what the hell does your personal physician know? First, we disable you and now you're not disabled. Which is it? So he's now, he's terminated. He's gotten terminated. They said there's no way we can accommodate this. We work 24-hour shifts. We don't have 12-hour shifts. Great issue for the fire service, right? Great case for this blog. But nonetheless, he's suing because, hey, I was released by my personal physician with no restrictions, and now you're not giving me personal restrictions. Which is it? So this is just a lawsuit, right? Just a lawsuit. But I think and Curt, you could have a different view, or although I'm stealing it from you, but I think the most interesting issue is the failure to assign somebody, well, two issues, to light duty forever. Is that unreasonable as an accommodation? I think the answer is going to be no. Light duty is temporary, always meant to be temporary, not permanent. And if your doctor said, right, it would be different if this doctor said,
what do your policies say?
Yeah, exactly. Yes, yeah, exactly. I always tell people the first question your attorney's going to ask you is, what are your policies? And then the second part is, well, wait a minute, we have a 24-hour shift. Do I have to make a special exception to you, giving you a 12-hour shift, right? And no way is that going to be a reasonable accommodation. Your union has bargained, I presume, for a 20. They like 24 hours. They hate 12. We saw that as retaliatory way back when they give 12-hour shifts. And the third is, there's four really that I go on, but the third one is, well, wait a minute. He had another doctor's opinion, and his doctor changed his opinion, but we have department doctor versus personal doctor. Who do you have to rely on for this purpose? FMLA, just to throw this out there, you have to rely on the person's personal physician, not yours. But this is not FMLA. So, and then, well, what about if he had another exam, right? Because initially they're saying, well, we're going to put him, in September, in another 5 months, 6 months, whatever it was, he's going to have another exam and things could change. Well, how long do we have to wait? So I think they win. I don't think there's any way they could reasonably accommodate any of this. But back to you.
Yeah, no, I would like to see the case come out, because I think you got a factual question whether or not there is a way to accommodate his needs. I think you got another factual question. I didn't really think about this. I made an assumption that he was progressing to the point where the accommodation was no longer necessary. That his condition, whether it's through meds or whatever it may be, his condition had now stabilized, just like anyone else with some sort of a chronic health condition, that they got it stabilized, so he's no longer at any greater risk than anyone else is, and therefore he can work it, and that they ignored his doctor's conclusion. But I think there's some factual questions in there about just what his condition is. So
at least how they wrote the complaint creates some factual questions. But if it's the circumstances, how I guess interpreted them to be, I think they get to move to dismiss and say, listen, even if everything he's saying is true, we refuse to accommodate him by giving him a 24-hour shift when it was 12, and we refuse to accept his same doctor's second changing, totally reversal opinion. I think they win. I think they can get rid of this on a motion. So we may see this much sooner than later.
Yeah. Okay.
Lastly, let's go to Minnesota. Again, like I said, this is kind of disability day, except for the stripper at the beginning.
They do seem to come out in groups, though. I don't know if the federal courts handle it this way, and certainly the filing of them, they don't happen. But just seems like you see a case in one circuit on the same issue and another one in like 1 or 2 days apart. So
yeah. So here's just another lawsuit. I don't know. It makes for a great video. So for us, so here's a Minnesota paid fire captain. He's claiming that he's been discriminated against because he was terminated in March of this year, 22. And this is the PTSD case. He claims he was suffering from PTSD. He claimed he was suicidal when he went off in September 21. The diagnosis was confirmed by medical professionals, as were 2 suicide attempts. And one was in September, one in October. So in March 22, he was reevaluated, still found to be unfit for duty. His clinician recommended continued therapy and that he be reevaluated in September. So this is maybe where I'm getting the reevaluation part. So now we've got to wait till September. And what if that outcome is you need another reevaluation? And we'll just keep you on forever until, you have no more reevaluations. But in any event, he's then terminated prior to September of 22. He's terminated in May of 22. The city is saying, listen, he's unfit. He's just unfit. He can't do work as a firefighter, and his absence had a significant impact on the day-to-day operations of the fire department, so we can't accommodate him. They said, and the city did what was right. I think this always puts you in a good position, right? We accommodated him with a leave for 7.5 months, way beyond anything he needed. And it's important because it takes out most of your FMLA claims. It takes out some of your ADA claims because you've tried to accommodate them and it's no longer reasonable to do so, right? A temporary accommodation, I think, is unreasonable not to temporarily accommodate someone if you can. And if you're a big department, you certainly can. Maybe not a small department, but a big department could. Minnesota's pretty big. So in any event, they gave him 7.5 months and he was not found to be fit for duty. And there was no definite time. That's the important part for a possible return. So he argues in his lawsuit that he's had no relapses in this short time period. He would have been cleared to return to duty in September had the city not terminated him. Well, there's no way to know that other than, okay, well, you got to September and he says you're cleared. But so that's the great question, I think, of this case. What if you could be cleared for duty in the future? All your time has been utilized before that. Does the city, the employer, have the obligation as to reasonably accommodate you by continuously extending your time in the hope that a future, right? I don't think so. But let's not confuse this with I had surgery. My healing time is 3 months and I'll be back in 3 months. Not the same thing. I didn't want it because I'm like, oh, you could go that way. That's not this. This is you have it's a mental condition. There's no clear way to evaluate a perfect result. There's no clear way to say your muscles are healing and blah, 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 and your strength is this. You can't do that here. So this is different than you had an injury and you're going for cleared for duty and we're trying to terminate you before your clear for duty exam. This is, you have an unknown, when is this ever going to resolve itself type injury. And I think he loses. I think the city did what they should have done, and they went above and beyond for this part.
Yeah, I think that this case kind of, to me, and the last one as well, shows sort of the progression from FMLA to ADA, that the first 12 weeks, when you have some sort of, whether it's psychological or physical or other health condition or family member, whatever it may be, the first 12 weeks, as long as the the fire department handles it properly, gives the notice and all that, you've got protection, okay? And it's going to end after 12 weeks. Then you're into an ADA situation. Now, this was actually filed under the Minnesota Human Rights Act, so probably has analogous protections and probably has maybe some more employee-friendly protections in the ADA. But bottom line is this is going to be probably staying in state court on that state court issue of disability discrimination. But once the FMLA protections have expired, and by the way, I don't know if I mentioned this to you, Rhode Island has a Family Medical Leave Act that goes for 13 weeks.
Oh,
so
up on you.
So, right. So I don't, yeah, right. So, and the reason I point that out is I don't know what Minnesota's has as well. There may be some additional protections and nuances in there. So bottom line is, once your FMLA protection, ends, then you're into an ADA analysis. And, there's some factual questions there, but I think at some point, everyone would agree at some point enough is enough. Whether or not 7.5 months is going to be it, that's going to be up for the courts to work through.
Right. And I think if this was a surgery case, because I don't want people to say, oh, we can just give him a set amount of time and forget his future, reevaluation. No.
Right.
It's not surgery or healing from an injury. Something like this, which is there's no indication that you're ever going to be fit.
We have better data on that. Okay,
right.
The doctors know, and really the workers' comp systems and health insurers have tremendous data on this about how long it takes. If you have a fractured clavicle, or you have fractured humerus or, tib, fib, whatever it's going to be. They have data about how long it's going to take, what the normal course is going to be. And maybe there is, maybe there's not. I'm not a psychologist or psychiatrist. Maybe they do, maybe they don't. Those are all some of the factual questions that are going to be there. But just seems to me, particularly when someone is at risk of suicide, it may be more difficult to predict the normal course of that particular condition.
Right. And hey, let me ask you something. So, in none of these cases have we seen the union coming to anybody's assistance. I'm wondering, would we know, right? If it was a union hired attorney, maybe we wouldn't know, but normally they say they refer to the union. Did you see in any of these, has the union come? Because I wouldn't. If I'm the union, I'm like, no, right?
Yeah.
But
no, I didn't, and I'm assuming Brooklyn Park. I mean, there's a lot of IAFF locals in Minnesota, and I'm assuming that Brooklyn Park, has an IAFF local. But some of these are not. Like when the course of action for the union is to file a grievance, right, and that may also be going on. There could be that track. Some states you've got to make an election of remedies, so you're gonna go the grievance route or the civil service route, or you're going to go to federal court or state court and handle it that way. So, but it could be, I know I do not licensed in Mass, but I end up, getting dragged into some cases in Mass from time to time. And, you have your collective bargaining grievances, you have the Mass civil service system, which, and then you have the option to go to court, and you get a lot of finger pointing. Hey, you came to court, you should have went there, or you came to civil service, you should have went to grievance.
Do it all.
You should have went there. And
right,
there's a lot of finger pointing, and I thank God I don't practice there. So,
well, as we're now at the end, let me just take this moment as we talk about licensing is to congratulate my associate, Zach, who is his score was so high he can practice in 35 states.
Wow.
So we're going to send him to 35 states now. No, we will expand to a few states, but he scored exceptionally high. Even New York, I think, is probably one of the hardest bars to pass, which is where I'm located. So my request was, I hope you get obviously New York. If you can get New Jersey and any other states, great. So
I want a commission. I want a commission on all of his billable hours, because I brought him. Zach to you. I got Zach to you.
Yes, so. You were the Zach referrer. If he sucks, I'll blame it on you. No.
Oh yeah, I guess I've got to take the hit on that one too.
Right. So, but he may be our guest at one point. If I'm not here in the future, he'll sub in.
Absolutely.
And he would love it. So perfect. Well, that's what we got today. And that was I love Disability and Stripper Day. Look, anytime you can start with talking about a stripper getting out of a fire truck, we're going to have a good session.
All right. And that's going to do it for another edition of Fire Law Roundup. Brad, we'll see you next week.
Have a great one.